myself. My apologies. My name is Earl Viner. We had a few issues getting this working, but my tax experience includes over 35 years of preparing SR&ED investment tax credit plans for both large and small clients from a wide range of industries. Having established Viner R&D tax specialist, I've fostered SR&D tax-focused firm combining uniquely specialized individuals with a common goal to provide a high-quality, personalized, professional, tax-oriented service, including planning, follow-through, and optimal compliance while maintaining a sense of humor. Our firm continues to update the Carswell Guide to the Taxation of R&D Expenses, a 3-volume reference manual used by accounting law firms across Canada. I am going to turn it over shortly to Justin, who's going to take us through the Vortex case. You can see that we've listed 5 cases we're going to go through. The last one very, very quick, but Justin brings over 22 years of experience with the SR&D program, working domestically and in countries that have adopted the Canadian model. He trained under one of the earliest RTAs who established a private practice in Northern Ontario and has consistently served clients in the 705 and 807 area codes throughout his career, including currently. Justin's practice today includes a small group of highly specialized professionals with offices in both Western Toronto and Thunder Bay. So without further ado, I'm going to turn it over to Justin. So Justin, please put your camera on.
Should be on. Actually, if I may, oh, you can't hear me? I am experiencing a couple of, oh. Is that any more clear? I am experiencing a few technical difficulties. If you wouldn't mind maybe moving to Manning, and then I'll catch on after that. Is that okay?
Fine with me.
Oh, thank you. I appreciate that.
Oh, you want to do an introduction or I'll just jump right in? Okay, I guess I'll take it from here. My name is Ohad Una. I've been dealing with SR&ED for 24 years, the last 15 of which working with Earl. My background is as an engineering manager in aerospace and defense industry. So, Manning case. Earl, are you there?
Sorry, what happened to Justin?
He needs more time. He handed things over to me, so we're going to start with Manning.
Okay, before we do that, let me introduce you at least. Ohad has an engineering management background, mostly in the aerospace defense industry. He's been doing SR&ED for 24 years and with me for the past 15 years. So with that, I will get to your case very quickly. Manning Kitchens, here we go.
Yep. This one was a win for the appellant, but while the appeal was a win, there's a few serious mistakes done here by the claimant, and I'll get to that later. You'll see the reference to the paragraphs in the judgment on each section here. This was, by the way, the informal procedure. So Manning is a Toronto-based producer of healthy drinks and preservative-free beverages, basically. We're talking about tax year 2020. Product was a vinegar cold-pressed juice soda. And the questions here were whether the development constituted SR&ED. Okay, the result was the appeal was allowed and sent back to CRA for reassessment. Okay, it was as usual. The baseline here was Northwest Hydraulics, the 5 questions. Did the work involve a technological uncertainty? Minister, okay, this was the first one where they didn't agree. Minister claimed that this was routine engineering. By the way, I don't know if you all noticed, but CRA has removed the phrase routine engineering from all the literature and replaced it with engineering. So basically, all engineering is now assumed to be routine unless proven otherwise. Just a side note. And the appellant, of course, argued that there was novel development here. Judge found the appellant, Christine Manning, to be credible, and despite not having a scientific or engineering background, accepted her testimony at face value. Respondent here was the RTA, Rahmat Nazarali. Also, the judge found her to be honest and experienced in the field. No expert witnesses were called. Next, please. Now, the objective here. And this was one of the issues under dispute. The appellant claimed that the objective was to create a non-refrigerated, shelf-stable, cold-press juice, vinegar, soda with or without preservatives. That was left aside. The problem was that this was not what was described on part 2 of the T661. And I've had audits with Ms. Nazarali, and she's one of those RTAs who actually reads the part 2 before the audit and comes prepared. So this was an issue, a contentious issue. And again, I'll get to that later. The problem that the claimant faced was that the cans were exploding because of microorganism emitting oxygen into the sealed cans. Okay. And yes, as I said, the minister claimed that the only objective stated in the T661 was to increase the shelf life of the juice, of the canned juice. And heated and refrigerated solutions are routine in this industry, which is why the claim was initially rejected. The objective of non-refrigerated product was not mentioned on the T661. Now, this the court accepted the appellant's definition of the objective, and as such found that there is a technological uncertainty in this work. The exploding cans were seen by the court as proof of the uncertainty and of the advancement being sought. And the fact that no other product that meets those requirements existed was seen as supporting evidence to the fact of the existence of technological uncertainty. Next, please. Now, the original goal was to find, to develop a product without preservatives. When that failed, the appellant tried several different preservatives, including sorbate, benzoate, and a new one, chiber. Chiber is sorbate and benzoate are standard preservative in the citrus and juice product market. Chiber is a newer product based on mushrooms, which is currently used only on dairy products. never been used in the juice industry at all till this point. So the application of this preservative in non-dairy beverage was seen by the court as novel, and it did in fact solve the microbial instability and stop the explosion. Okay, the court saw this as exceeding routine engineering. It was an application of an existing method to a new type of product which was not applied to it before. Going to the scientific method, court found that there was a formed hypothesis, observation, conducted measurements including pH, Brix, carbonation, and they were tested systematically. That was not contested by the minister. Next. There was a technological advancement achieved by creating a shelf-stable cold-pressed juice with use of a preservative, namely the Chiber one, which was never previously used in such an application. Documentation, again, the two sides did not agree. What the minister claimed is that no adequate documentation was presented to them in the audit. And now I've been audited by Ms. Nazarali, and she's a tough RTA, but she's honest and fair. So when she claims that no adequate documentation was presented, I would assume that that was really the case. Now, the appellant in this case presented what the court called a sample of documentation. My guess is that they presented everything they had on hand. Court cited dual theatrical rigging and les abeilles to say that written contemporaneous record is not absolutely essential, and basically played down the role of documentation in this case. And the judge did not review the actual evidence, saying that he's not technical, and no technical expert was called to testify. And he reminded the respondent that documentation should be assessed based on its usability to the claimant, right? And he accepted the claim that it was sufficient to maintain adequate control over the development process. Okay. Conclusion was that all 5 criteria of Northwest Hydraulic were satisfied, and the appeal was allowed. Reassessment was ordered by CRA. Now, I want to get back to the issues I mentioned before. This was an informal procedure, so I expect it to have a very minor impact on future cases. But even though it was a win for the appellant, our goal is not to win appeals, but to avoid appeals. And I believe this could have easily been avoided if the original goal of a non-refrigerated product was stated clearly on the part 2, ideally as the project title. I don't know how many of you were in the lecture I gave a few years ago about coming up with a winning title for your T661 project. But as a minimum, the goal should be stated this way. It should be stated clearly. Now, What we often see from claimants is what I call the post hoc objective, or basically throwing a dart at an empty board and drawing a bullseye around it to define an objective. And our role as consultants is to dig deeper and find the original objective, even if it wasn't met. Claimants want to show success, but our goal is different. Our goal is to show the uncertainties which were not properly shown in the part 2 here. And the other item to notice here is that the documentation threshold at TCC is very often lower than at an audit. So if your claim is rejected solely based on lack of documentation, then you should seriously consider an appeal. That's it. That's all I have for this one.
Thank you, Ohad. We're going to go back to the beginning now, and Justin is ready.
I am ready. Apologize for that.
Thank you. Vortex.
So actually, I might diverge a little bit from the slides here. I can just do it verbally. So this is Vortex v. the King. Basically, the takeaway here, among others, trial and error is still not SRED. This is a company that submitted SRED claims relating to the development of mobile, high-efficiency, direct contact water heaters used in hydraulic fracturing or fracking. Decision is a useful reminder that complex, risky engineering work doesn't automatically assume that it's SRED. And the other piece, which kind of raised my eyebrow, was that in engineering cases, expert evidence and documentation are now close to essential, which we'll get into why, particularly with the expert evidence piece. That's why this was a challenge. Now, the facts of the case: Vortex set out to build mobile direct contact water heaters. This is between 10 and 35 million BTU, so these are big fellas. They could be mounted on a truck or trailer, used at remote frac sites. Existing direct contact heaters were stationary. Vortex wanted equivalent output in a smaller mobile package that could survive extreme weather and transport vibrations. So you would think on the face of it that maybe there was SRED, and maybe there was. But so in 2014, they worked mainly on two 10 million BTU units. One, according to the taxpayer, failed catastrophically during testing when vibration cracked welds and shook the whole unit apart. 2015, they focused on a single 35 million BTU unit. In 2014, they'd claimed 1.45 million in expenditures. And in 2015, about $500,000 in expenditures. 2015 claim was not objected to directly, but carried forward into 2019, and both years were ultimately before the court. By the time of the trial, Vortex was operating the surviving 10 million BTU unit and the 35 million BTU unit commercially in the field. Minister's reassessments. Oh, I will hit. Do not disturb on that. I apologize. Minister's reassessments denied all SRED and crucially assumed that there was no scientific or technological uncertainty, no hypotheses, no systematic investigation, and no technological advancement. The Crown successfully amended the replies at the start of the trial to make these assumptions explicit, relying on the CRA reviewer's report. So in the legal framework, of course, you can talk about why and how and whatever the flavor of the day is for interpretation. But Northwest Hydraulics still rules. Justice Spiro reaffirmed that the 5 questions at Northwest remain the operative framework. And of course, I won't go through those. We all know Northwest Hydraulics. The court walked through each question and found that Vortex was wanting on all 5. Vortex did plead that it faced uncertainty in dealing with large swings in ambient temperature, large swings in inlet water temperature, and making a much smaller heating chamber work, which was about 60% of the conventional size of the fixed unit. The court's response was pretty blunt. Technological uncertainty is objective, not subjective. The question of whether a competent professional in the field would find uncertainty was the order of the day, not what this particular taxpayer did or didn't know. Vortex called no, and this is this references the beginning. Vortex called no expert engineering witnesses to explain the state-of-the-art in burner design, vibration or harmonics in welding vessels, or mobile heater design, nor to explain why the difficulties they encountered couldn't have been solved by routine engineering and known calculations. Because the minister had explicitly assumed no scientific or technological uncertainty, and the assumption was never demolished, the court essentially stopped there on criterion 1, the taxpayer failed at the threshold. There's also strong practical comment to the bar. In engineering SR&ED cases, relying solely on an owner or founder's testimony is risky. An independent expert bound by the court's expert code is considerably more credible and reliable than simply an interested witness. Furthermore, one big hypothesis isn't enough. Vortex's pleadings identified a single overarching hypothesis that a new set of engineering guidelines and software controls could produce a working mobile direct-fired heater, but that's not a hypothesis at all, replied the court, just a restatement of project objective. Hypothesis must, of course, be specific, testable statements that you can prove or disprove with an experiment. I mean, I can continue on with these, but quite frankly, I found there to be 7 takeaways for key for software, sorry, for practitioners. Uncertainty, being objective and context-based. Don't frame, we didn't know how to do it as an uncertainty, but rather frame what competent professionals in the field would find non-trivial and document why standard design calculations, codes, supplier knowledge, and so on was not sufficient. If you end up in court or in dispute, bring in an expert in engineering cases. When the dispute is about what is routine engineering versus experimental development, an independent engineering expert is increasingly critical, if not the standard. Might be one of the implicit pieces of might be one of precedent in this particular case. Without one, the court is most likely to accept CRA's assumptions that no real technological uncertainty or advancement existed. The work must be broken up into specific testable hypotheses. Avoid the one big hypothesis that just restates the project goal. For each technical issue, flame stability, harmonics, weld fatigue, spray nozzle performance, define a hypothesis, test it, and record what changed. Designing a systematic experimental program is not just a tuning exercise. Trial and error is common in engineering. To qualify as SR&ED, you need to show that each trial was part of a structured plan to understand underlying phenomena, not just to get the equipment to behave the way you want it to. Document everything, especially failures. Contemporaneous lab books, test sheets, logs, and design notes that link problem, hypothesis, test setup, measured data, analysis, next step. Right, following the scientific method. Failures are valuable evidence of learning. Omitting them can be fatal. Couple more here. Commercial novelty isn't enough. Being first to market with a mobile direct contact heater did not by itself convince the court, nor should it have. Make sure your files speak to how the work advanced the underlying knowledge, not just that the product is unique or successful. And watch the assumptions in the reply here. The Crown strengthened its assumptions at the start of trial to explicitly negate all 5 Northwest criteria. Always read the reply assumptions closely and build your evidence strategy around demolishing them point by point, but to Ohad's initial point, try not to get here in the first place. In short, Vortex continues the recent trend of the tax court, tightening expectations on SR&ED evidence, specifically in engineering projects. For practitioners, I would say it's a cautionary tale. Impressive prototypes, dramatic failures are not enough. Without clearly framed uncertainties, hypotheses, systematic tests, and strong documentation, even very sophisticated engineering work may be characterized as routine. Thank you.
Thank you, Justin. We are now going to go on to the next case, and David Sabina from UC probably needs no introduction as he's been doing SR&ED since 1994 and is the main driving force behind these yearly stakeholder events. David's published in R&D tax issues for professional accounting bodies and industry. As He's a primary development partner of rdbase.net. He works with accounting, tax, legal, patent, market development, and investment specialists to coordinate development efforts and commercialize intellectual property. Let me see if I can get to right here. So with that, Dave, if you don't mind taking it away.
Excellent. Thank you, Earl. Okay, I'll jump right into DASM. What we have here in the slideshow in general is a case summary where we've cross-referenced the actual paragraph questions from the tax court judgment itself. So you can follow it through or double-check things if you're interested. Okay, so basically the case is a company that provides software as a service. They have a platform, and they filed a partially successful claim for the 2018 taxation year. So basically, the CRA originally allowed about $8,000 of a $278,000 claim. They subsequently allowed several what they call sub-projects, or we might call it activities, supporting activities within the project totaling $61,000. And the remaining, what they call sub-project 1, was the lion's share of the costs, or around almost $210,000. And it was related to getting components to integrate effectively. Okay? So effectively, the overall project was to create a metadata architecture. So what they wanted to do was they wanted to take an application from Windows to a cloud application, and had several activities, or what the CRA called sub-projects, within that. So one of the key sub-projects, and one of the things that fell into contention here, was really the use of how to get the metadata to have dynamic fields. And there was thousands apply the metadata architecture, the tool chain overhead exploded and caused crashes. So the interaction of different components between the core components, React, Redux, stylized components, and what they call the high order components were interacting in a way that wasn't isolated, and which they couldn't figure out. Okay, so basically what we have here is a very complicated slide, but it gives an overview of the project itself and the related activity. The activity being the React performance integration that was in dispute. So the technological uncertainty at a high level that was accepted by the CRA initially was whether we can create a metadata-driven architecture to deliver the acceptable performance. And the sub-project, the issue that they had a problem with, was really work related to the specific tool combinations and activities related to providing that metadata architecture within a reasonable time frame. Okay. So the original technical challenge of the activity was that related to the project was to create a renderable time frame of 300 milliseconds versus the current time frame of 1300 milliseconds, which would seem to be unacceptable. Ultimately, they were able to achieve a reduction to 692 milliseconds, but this was still seemed to be a business failure, so it didn't meet the business criteria, although it was a technological advancement in that they determined some of the issues causing it. The experimentation that was noted to within the case itself was work that first started on doing small optimizations, which resulted in roughly a 10% improvement. Then they analyzed component interactions. They consulted public domain information from GitHub, other solutions. They looked at React diagnostic and talked to the developers of the React platform itself, who couldn't solve their issues here. And then they built custom diagnostic tools to identify which nodes were causing the problems. Through this and modifying source code, they were able to reduce the response time to 775 milliseconds. And then through additional focus on the higher components, they were able to reduce it to 692 milliseconds, but still concluded that that was not successful from a business standpoint. Okay. So some of the court's key findings is that there was system uncertainty due to the tool chain interaction. And most importantly, that we wanted to evaluate the eligibility at the project rather than the activity level, okay? And that ultimately the work on what we called subproject 1 was more than just debugging. It was basically a systematic search or activity that was directly in support of the project itself. So the courts felt that you should adjust or evaluate the project holistically, the entire project within the objectives, not each activity separately. And as long as the activity was supporting achievement of the overall objectives and resolving the stated technological uncertainty, it was eligible. Okay, so the activity was actually necessary for the project as a whole. So ultimately, why the case? One, several factors is that the
recording stopped.
Sorry. So some of the key factors were that there was the architectural context itself of the different components being integrated created technological uncertainty that wasn't routine, that wasn't readily available solutions. The CRA expert in this case wasn't familiar with those components or the specific limitations, so that added to the claimant's favor, and that ultimately they were able to provide metrics, response times, things like that, measurable components, so things that are systematic in order to support the eligibility. Okay, so some of the key lessons and how we can apply this to our own claims are you want to show how sub-projects or activities support the overall project objectives. You want to capture hypothesis and measurements, so things like more node counts, response times, things like that. Very important to document public domain search responses and why they're not applicable. And it illustrates that a modern framework, even modern frameworks can create technological uncertainty when we try to integrate them. Okay.
Thank you, David.
Thank you.
I'm going to turn it over to Sean Button, and he has a background in materials engineering, 15 years experience, technical consulting in the SR&ED industry. He started with David at Muke, recently was a senior manager at Ryan, and is now an independent contractor under his company, Insight SR&D Solutions. So with that, I turn it over to Sean.
Thanks, Earl. So I'm going to talk about Pavit. So this is a small company out in Alberta. They wanted to come up with a process to use a mobile mixer developed by a separate company to reach remote sites and apply this mobile roller compacted concrete. So the key thing here is determining whether this was experimental development, and we'll see that they lost similar to Vortex. So their idea was that this mobile mixer would solve the problem of transporting this concrete from fixed sites where during that transportation the crystals that form are degraded. So they wanted to come up with a process where they're using lower water content to improve the strength, where this is a typical or a difficult concrete to apply. It's harder to mix and lay. So they're testing the durability of the machine, the maintenance of it, and safety, along with the mix formulations to apply this on site. So there's good potential for improvement here, but does it meet technological advancement? We'll see that the courts disagreed with this. The claimant did not bring in an expert witness, to support the innovations, which was really needed to substantiate beyond their existing claims. So we needed to distinguish here what the gaps were in the existing knowledge versus the argued process breakthroughs. So really they were tasked with rebutting the CRA's assumptions, and the burden was put on the taxpayer to prove the existence of SR&ED in this case. So they really relied on a guide for optimizing for this type of concrete. And we'll see that the appellant had issues in cross-examination. For example, they admitted that they didn't read all of the guide. They did have a representative, but the representative was considered a advocate and not an objective witness. And they lacked the objective proof to really make their case. So these were real-world applications of the process they were trying to develop. And so their testing was limited. They only had standard strength testing of their new process. They really focused on the low water use and faster compaction as the unique aspects of the project. But these were considered routine by the courts, and this was really backed up by the lack of evidence that they had gone beyond routine optimizations to provide a technological advancement. So this was really just figuring out how to do this on site, a business advancement, but without evidence of publications or anything like that. It was considered by the courts to not be a technological advancement and fell within the guide. And really what it fell apart on is the documentation. So they were unable to demonstrate that they had a systematic process in this case. They really only kept some journal entries and didn't really show the systematic process. So this is really essential. We've seen this under Northwest Hydraulic, that we need to prove there's a hypothesis, systematic method, results analysis, and so on. And just relying on the defendant to make their case, they couldn't back it up with significant evidence. So this is a common pitfall in the industry, especially when you're doing this on commercial sites. You want the evidence of the scientific work. So in this case, we see that the onus is really on the on Pavit to disprove CRA's assumptions. The CRA didn't bring in an expert witness, and were able to get some key admissions from the cross-examination. So we've seen this as CRA's approach when the taxpayer evidence is weak. And yeah, so the cross-examination really didn't go well for the appellant. The judge commented that they were honest and candid, even when admitting unhelpful facts. And again, without the documentation, that's all they had to rely on. Again, we see that the ministerial assumptions were presumed correct, and the taxpayer failed to disprove those. They didn't have a hypothesis that they can articulate, and essentially it fell apart on all 5 criteria. And so both sides really relied on the guide as the key piece of evidence, and it ended up working against Pavit because they essentially followed what was in the guide. There was some indication that they went beyond it in terms of efforts to retain moisture, but it wasn't enough. They saw that they're working within the parameters outlined in the guides. So they really need to show how it goes beyond those indicators in the guide or the standard practice for it to be SRED. So the CRA really focused on exploiting gaps in the case rather than presenting why it wasn't SRED. And so the takeaway in this that it really needs to be a robust claim. Again, bringing in experts can help give an objective view on the standard practice to be able to withstand that scrutiny. So key takeaways, we've got an example here of what is trial and error in field testing, and especially when it's commercial field testing, there really needs to be evidence that you are controlling variables, right? You're there out in the field, it's really hard to keep track of what's changing considering the weather and the amount of variables involved. So we need strong evidence that this field testing involves the hypothesis and systematic testing and so on, and that there is a knowledge gap in what they're trying to achieve.
Thank you very much, Sean. We're going to go on very quickly. We're going to discuss, David's going to talk about BlackBerry for 1 minute because I do believe in 99% of the cases this will not be relevant for anybody, especially since half of you will not know or care or need to know or care what FAPI is. David, do you want to make a comment on this? I mean, it's foreign R&D. It's R&D because it's foreign R&D, but I don't know if you want to add anything to that.
Thanks, Earl. Ultimately, all I wanted to say is that if you're involved with this, you probably are aware of it, and that probably the main takeaway is that if you're doing foreign R&D, it's documented properly, it's probably not, the income resulting from that is probably not considered to be FAPI income, and we could probably just leave it at that.
Perfect. Thank you very much. We actually have a few minutes. We're a bit ahead of schedule. So if anyone has any questions related to the cases so far, feel free to put your hand up and I will allow you to unmute and ask your question. Or if you're shy, you can send it in to me and I will be happy to read it out loud for someone to answer it. In fact, we are fortunate enough to have the DASM, and I probably destroyed the pronunciation of the case, consultant here. So if there's any specific to that, we have a person that can answer it directly. I don't see any raised hands, but feel free to send something in the chat to me. Okay, we do have one question. Well, no, we're just saying Romaine has offered to answer questions, but nobody has any questions. Thank you very much. Then we are going to move on now, and we are going to start the next thing is Ben. Ben is back again this year. We're happy to have him back. Benjamin Max, principal and patent attorney at Smart and Bigger. Many artificial intelligence AI companies can generate complex technologies that are confusing for others to understand.
Benjamin assists AI companies in building their patent strategy that clearly tells the story of the invention to their stakeholders and to the patent offices. So with that, and without further ado, Ben, if you want to start sharing your screen. You are. Excellent. Take it away.
All right. Thanks, Earl. Hopefully everyone can hear me. So I will today talk about software patents and more particularly AI patents. In the past, we have spoken about patentability of AI and software. So this is more about updates, but there is sort of a rich history of software patents at the U.S. Patent Office. So today in our 20 minutes, we can only talk about the updates, but I'm happy to chat offline about the general tests. So this is just sort of what's happened in the last few months, in fact, as recently as August. So since this is a good year in review. Okay, so there we go. This is my firm. It is Smart & Bigger. That was actually the names of the lawyers at the time, and we're happy to help with full service IP and patent work. This is me. I am a lawyer and a patent agent. Okay, so today we'll talk about kind of four main things, but really focusing on the first two. So there's new guidelines on patents, patentability of AI. There was a recent decision regarding AI, and then there were two other updates, which we will talk about briefly, because one of them even, in fact, came out yesterday. But generally, for those who are a little lost, I'm talking about patents today. I'm not talking about SR&ED, although there may be some overlap in concepts and the idea of trying to bring some ideas and thoughts and abstract algorithms onto a computer. A lot of the challenges are similar, let's say. Okay, so new guidelines. New guidelines issued in August, which is fairly recently. It's an add-on to previous guidelines. We call 101 the same thing as these abstract guidelines. So really the question is your software, let's say, technical enough? And if it's technical enough, then it can go into the patent office and then do the remaining examinations, which is usually novelty and inventiveness and some other things. But 101, which is literally the first provision of the Patent Act in the US, just says it has to be an invention, it has to be a patentable method of some sort, a patentable process. So the question is whether that process is just a mental process or a technical process through your computer. Okay, so the memo came out, as it says this is not intended to introduce new practices, but it is a reminder to examiners, which is a sort of a code word, but as we can see, a lot of the language is pro-patent and pro-AI patent. And they did have a note on close calls, which is 50-50. And they say actually 50-50 goes to the patent applicant in terms of approving it, in terms of whether it's technical enough. We're not talking about obviousness today, other than if it goes into these considerations. Generally, we're just going to talk about, let's just say, is it technical enough? Is it not an abstract idea? Is it not a mental process? Is it not a mere algorithm? So some of these things are tests because, again, they are add-on. But on a very high level, if you want to assess whether something is patentable, has to be something, a process, a machine, a manufacture, and composition of matter. That's literally 101 of the U.S. Patent Act, and the controversy is whether the process can be a computer-implemented process, or for the machine, whether the computer as a machine is patentable because it's programmed with sufficient technicality. Step two is then we look into is the claim directed to one of the judicial exceptions, mostly being abstract idea. We can talk about law of nature and natural phenomenon later, but generally a lot of these coding concepts are abstract ideas that we're putting onto a computer. And then 2B is, does the claim recite additional elements that amount to significantly more than the recited judicial exception itself? So I don't want to belabor things too much because, again, we're not getting to the new part yet, but there is sort of this test of whether something is patentable. Step one, it's a bit convoluted, but let's go through a little bit of it anyway. Step one is, again, is the claim invention fall into at least one of a process, a machine, a manufacture, or composition of matter. If it's not even pretending to be one of those categories, then it's not patentable. So let's just say it's yes. Let's go to step two, which they've now broken up into two steps, 2A and 2B. 2A being whether it's a judicial exception. Usually it's abstract idea. So we're trying to put an abstract idea onto a computer. And if the answer is no, so we can pass that sometimes and go right to patentable subject matter. Then they have 2B, which is, does it result in something significantly more than that exception? And sometimes that's where we bring in some novelty and inventiveness into the exercise. And the courts have decided, let's split up step 2A even more and then say prong one is an abstract idea, but then does it recite additional elements that integrate the judicial exception into what we call a practical application now, which, again, practical application is tough, like things like fintech, purchasing stocks, crypto, like how practical do you need to be for practical application? There have been cases, I can't recall whether they've been overturned, but even like a garage door opener, which is clearly a practical application, had a lot of algorithm behind it, and then at the end you would open and close the door, and then that one was strangely disputed and went pretty high up. Last I checked, the answer was no. I just don't know if they appealed it, but a practical application is tough to define, but in theory, you can pass at prong two, which is whether it's a practical application, and then it can still be saved by step 2B, the significantly more. And often the significantly more can't, it's hard to say, but sometimes it can't just be a human advantage or a human application, saying like, on your bank loan, what's your gender or your age, or, just things, what's the weather that day. So things that don't seem to be applicable to the technical solution. Rather, these seem to be more like human solutions. Okay, so what do they say? So mental processes are limitation, are okay. Well, it's mental if it could be performed by the human mind, okay? But we can't try to expand this definition too much. So they say it can't be practically be performed by the human mind. A really easy example is hardware-based RFID. That can't be done by the human mind. RFID being those short-range tapping your phone and security badges. That's what I mean by RFID. And that's the example they give. So obviously that is not a mental process. But when they talk about AI, they actually said we should look at that, and can that be done by the human mind practically? And they actually said, well, good for us, or for any patent owners, that a lot of AI and neural network training and things cannot be practically be performed by the human mind. Okay, so the judicial exception. So I'm going to read this example that they gave. Training the neural network in a first stage using the first training set. That is not a judicial exception, which means it is good. Let's just say that's yes, that's a yes. Strangely, they give another example, example 47, which is training by the computer, the artificial neural network based on the input data, and a selected training algorithm to generate a trained ANN, wherein the selected training algorithm includes a backpropagation algorithm and a gradient descent algorithm. So the first mistake was they used the word algorithm, call it something else. And this is probably the first time I've ever seen this. This is a personal commentary that the narrower claim is not allowed, but the broader claim is allowed because it didn't specify an algorithm, and an algorithm is a judicial exception. So very odd result. It's in the guidelines. So a lot of best practices are just kind of follow the language that they are doing. But you're still going to need support in your specification and figures and description of what types of algorithms would make sense for your neural network to work. But they said, well, example 39 didn't actually specify a specific algorithm, and that's a good thing, apparently. Anyway, so we'll go with what they said. Obviously, we'll just use the language as stated when needed in the future. Okay, so that's an interesting conclusion. Another thing is which is a favorable note, is they say, hey, when looking at the claim, analyze the whole claim as a whole. A claim is not just one line or one word. It's a whole paragraph if you've seen them, or sometimes they're a page. Sometimes they could be pages. But look at the whole claim, which is kind of a good point of emphasis. You can't just look at one little bit and try to analyze that bit in a bubble. Look at the whole claim. So that's great. They just keep hammering in the positive elements of the law that are in the favor of patent owners. And then you consider the claim limitations and how they all interact with each other. Again, you can't just take one limitation in a bubble and do the analysis. And then you look at the whole claim, and then you say, does at 2A prong 2, does the claim integrate this sort of exception into a practical application? So now you can say it by the practical application exception of the exception. And then if yes, you're good. And then no, you can be saved again later on. Okay, so improvements to the computer are good. That's usually how we try to frame it. It's tough when often AI is more accuracy, so trying to mimic human behavior and then be something more accurate. Let's just say a virtual therapist, something like that. So that, I can't say always, but often may be less considered to be important of accuracy or mimicking human behavior. It's like, how are we actually improving the computer? And then we consider the extent to which the claim covers that particular solution or method to achieve it. Is that improvement disclosed in the specification? But strangely, it says that the improvement to the computer doesn't have to be explicit. So let's just say we saved X amount of layers in our neural network, or less computation, which means less energy. Sometimes we can say it's less processing or better than whatever, rules-based, better than a fully connected neural network. Those are things that we try to focus upon. And they actually, again, this is very good language. We don't have to explicitly say it in the specification in the US. In other countries, it's probably good practice to do so. US, they say, well, would anyone have understood that using this algorithm would have improved the computer? Usually it's less processing, but it could be more efficiency to the answer, convergence to the answer quicker, rather than just saying it's more accurate for humans. Okay, so the apply consideration is usually it's a rejection. You can't just take a mere abstract algorithm and just say apply it on a computer. So that's still true. That's basically the definition of an abstract idea, that you are literally just saying, and then let's put it on a computer. But again, this is favorable. They said, let's avoid any oversimplification or expanding or summarizing. In other words, if the claim is a paragraph or multiple paragraphs long, you can't just paraphrase it into 3 words and say, we're doing a financial algorithm that's buy low, sell high. We can't just if it was a 3-page claim, we can't just simplify it into like 2 words and and then say, let's put that on the computer, and then reject the whole thing. So again, when the patent office is saying things like, let's avoid oversimplification, that's good for real tech owners who have done real technology. Also, obviously, there has to be an improvement. We can't do a mere algorithm that's already known and put that on a computer. So we have to figure out what was the actual algorithm that we're putting on the computer, and there will be some improvement in there, or else, why else would we be filing this patent? So of course, we're going to look for the newish part of the algorithm. Okay, and a similar note, you can't just say the computer is a mere tool, but it can be a tool. It just can't be merely a tool. So these are all positives in our favor. Okay, so for close calls, again, they've actually reiterated that you can only reject if it's more likely than not, this is a triple negative here, more likely than not that a claim is ineligible. In other words, it's, which is a strange burden, but we'll take it, that it's the examiner's burden. It's not us, it's not our burden to show patentability, it's the examiner's burden to show it's not patentable for this particular feature. And the examiner should not reject it because they are uncertain, of course. The burden appears to be on the U.S. Patent Office to first prove ineligibility rather than the applicant to prove eligibility. Again, good news. And rejection must be established by preponderance of evidence. In other words, they can't just provide conclusions, which is what we often get. Which again, they can't just paraphrase the claim into simplified form and then just say it's a computer. You have to actually flush out the whole argument, which is a lot of work for the examiner. And we're going to see something interesting later on that does seem to be a little more conclusion, again, in our favor, strangely. But again, you have to show evidence. You have to do the argument and analysis. You can't just say it. Say, oh, this looks like it's a mental idea. Okay, those are the new guidelines. Soon after the guidelines, there was a patent decision. So let's go through the case history first. So for patent office has to do an examination. That's the patent application number 040, owned by Google's DeepMind. Now, people are not supposed to look at the applicant, but I'm sure someone at some point looked at the applicant name, Google. And they had a method of training machine learning models on multiple tasks. Okay. It got rejected, so now we're up to the patent trial and appeal board stage, who affirmed the examiner's rejections. And then we're at the appeal review panel now, and that's what we're talking about today. Okay. So we're not at the federal court yet, we're at the appeal review panel of the patent office. So it is a transfer learning algorithm. The new USPTO director himself, John Squires, decided to just convene this panel, and he signed off on the decision himself, as well as two other very senior officers, acting commissioner of patents and vice chief administrative patent Judge Kim. And then vacated means vacated the rejection means they said it was patentable. Double negative there. So so what's happened? I don't want to get into the science, but if anyone knows anything about transfer of learning, basically you might learn to do one task, but then you can apply those learnings to a second task. So for example, this is my example, not the case, but you teach a robot arm to catch a ball, and then you might teach that robot arm to drink a glass of water, and the arm has to go reach the thing and do this task. It's a second task, but there are learnings that were made from the first task. So I don't want to get into it too much, but there are a lot of positives. So it looks like it's interesting technology. Improvement of the machine learning model, not a mere algorithm. And then once this model has been trained, the model can be used for each of the further tasks within some acceptable level of performance because you learned from the first task. So we wanted to avoid this catastrophic forgetting of the model. So I'm just presuming everyone knows about machine learning at this point. So this is a rather long claim. We have materials later, but it's not too sciencey either. It's actually kind of broad, frankly. But we have a computer implemented method of training a machine learning model. For brevity, we don't have time to read the whole claim, but so I'll just go to the emphasized parts, which is computing an approximation of a posterior distribution over possible values of the plurality of parameters, and then adjust the first values, that's the first task, of the plurality of parameters to optimize performance of the machine learning model on the second machine learning task, while protecting performance of the machine learning model on the first task. So it learns something, you're not ruining the first task, but you're using those learnings. A lot of this is actually called transfer learning, but let's assume it's new. Maybe this is a really old patent. It was filed, it's filed 2017-ish. This is not that old. Provisional was filed 2016, so it's oldish. Okay, so transfer learning probably came around 2016, maybe a few years before then. So maybe this was a foundational patent, which is why they want to get a patent on it. And it was filed in 2016. So maybe my learnings of transfer learning came from this for research. Okay, so back to the tests and the prongs. So they did agree with the examiner that this was an abstract idea. It's some sort of math. They said, yes, this is an abstract idea. But then on step 2A, prong 2, the appeal board held that the claims sufficiently reflect improvement on how the ML model operates. And specifically, they identified some improvements, which again don't have to be in the description, and effectively learning new tasks in succession whilst protecting knowledge about previous tasks, using less of their storage capacity and enabling reduced system complexity. I have a feeling they didn't write these in the spec. I do have this. We have the spec in materials if anyone wants to verify, but I think these were just post arguments that they did to try to get the patent through. But in the new guidelines, you don't have to actually explicitly say all the advantages and why it improves the computer. Okay, so here's this part of the claim did reflect the improvement. I did read it earlier, but it is adjusting the first values for the first task, for the second task, while protecting the first task. So the panel did essentially equate any machine learning to an algorithm with generic computer components. So that was the examiner. They said, well, you can't just say everything is a generic algorithm. So that's too high of a level of generality. Okay. They also said they did criticize the panel for being overbroad. Again, this is good language for good ammunition for us. You can't say it's overbroad, overbroad reasoning, and it seems to be just categorically excluding AI innovation, which, as we all know, will be the frontier for the next 10 to 100 years. So they can't just say it's all abstract because it's AI. And finally, on a personal note, 102, 103, and 112, like that's just like novelty, inventiveness, clarity. Like these are things that we should be focusing on, not 101, which is literally the first provision of the Patent Act, which just says, is this a method? We should focus on 102, 103, which is novelty, inventiveness, or obviousness, and 112, which is clarity. So let's focus on the real heart of the invention and not invalidating and disputing everything on 101, which is whether it's a suitable method for examination. And this is actually a long time coming that they would say this. Okay, so this was a reversal, first reversal, SME subject matter eligibility. This is a shift of how AI-related claims are analyzed. The USPTO has to show ineligibility. ML, obviously improving the model is good. And then he seems to have a pro-patent stance. Okay, that's topic 2. Topic 3 is really quick. As of yesterday, there's a new memo from Commissioner Squires, which says, so in a nutshell, I'm just going to tell you, so you still cannot name your AI computer as an inventor in the U.S. Patent Office. That's fine. But the AI can assist a human inventor, and you can still name the human inventor. The old guidelines actually required the human to have a significant contribution to the conception of the invention. And now the new guidelines just say that the inventor just has to have a contribution to the conception. So in other words, we're not changing the original test from the last 200 years. Just if you have contributed to an invention, you are named as an inventor. You still can't name a computer as an inventor, but that's fine. But at least someone is named as an inventor if they've done things. So an AI system is an analogous to lab equipment, your software tools, etc. And you can use those. And it's as if they were like your co-inventor. It's just you can't name them, which is, again, good news for all. Last one. Okay. So if someone has a software patent, you can actually try to invalidate them in the patent office. Something called an IPR, or inter partes review. And often these are used against software patents. So very recently, again, the commissioner has used this thing called a discretionary denial, which means he can use his discretion to just deny the appeal. In other words, if someone is trying to invalidate a software patent, the commissioner stepped in and just decided that he would use his discretion without reasoning to deny anyone trying to invalidate these particular software patents. And he did 13 of them and didn't give any reasoning. He just said, I have discretion under my legal power. I will now use that discretion to not even hear other people trying to invalidate these software patents for the same reasons we talked about, being an abstract idea, mere tool, mere algorithm. So that's why this is, again, good news for software patents, because even if someone, and it's cheaper to fight a software patent in the patent office than at court, and it's more predictable because at court they're assessing both the validity of the patent and whether you infringe. Whereas if you're fighting at the patent office for these IPRs, you are not, they don't address infringement at all. They're only addressing invalidity, which means, you're no worse off. You're just trying to invalidate someone else's patent. Anyways, the director has denied all of these, not all of them, but many invalidity proceedings using his own discretion. So whether this is political or legal or whatever, it doesn't matter. The point is the director is doing it. And I believe one of them has survived some sort of review at the court. Don't hold me to that. But the court just said, yeah, he has discretion, so we're not going to hear it, and it's within the rule of law, which is very odd. Okay, there's some takeaways that I provided here. I don't think they're that. It's hard to. You would just try to do best practices, as like we talked about. There's just have lots of claims of different scope, broad and narrow, because you never know what's going to hit. Like, I don't totally agree that a broader claim should be more patentable than a narrower one, so I wouldn't hold anything to anything other than just put it all in. So that's my conclusion. We have all these decisions and materials linked, and Dave will upload them to the portal. Or I think it's on the website already.
Yeah, it's actually
Any
up there.
questions? Okay, good. Can I take questions, or?
Yeah, we'll take questions at the end.
Okay.
So keep your
Thanks.
questions. Thank you, Ben. We're now going to turn it back to David. David, if you want to talk about the new AI guidelines and share your screen, please.
Oh, do you have it, Earl? I thought you were going to run it for me. Or do you want me to load it
Okay,
up?
I can run it for you. Just
All
give
right.
me a minute then. I got to download the latest and greatest.
No worries. Yeah, well, anyways, as Earl loads that up, I'll just get into it quickly. We've talked about the effects of AI on SR&ED credits over the past couple of years, probably about 4 years now, with different guidelines being put out by the CRA, as well as the U.S. Patent Office last year. This year, in the last year or so, almost every other jurisdiction, including Canada, Japan, Europe, UK, have all come up with their own guidelines and examples. So what we were hoping to do in this section of it is just to highlight what those examples are, maybe talk about one or two of them per jurisdiction, and then talk about some of the commonalities between the jurisdictions and how they define related AI advancements, and some of the differences or dichotomies that we see coming up. Are you good on that yet, Earl?
I'm about 1 second away.
Okay, no worries.
Okay, people should be able to see the screen now.
Excellent, thank you. All right, so go ahead, please. So, as we said in the last year or two, almost every major jurisdiction has come up with some major guidelines and a series of examples for using AI, both AI on its own, what would be a technological advancement, and using AI more to develop other products or processes. So Japan is the leader with 25 new examples, of which 13 are eligible, 7 are ineligible, and 5 are kind of partially eligible. UK is next in the number of responses with 18 examples published. Of those, 12 are eligible and 6 are ineligible. So again, what they try to do here is to give you illustrations of both what would be in, what won't be in, and kind of what's borderline as well. So as we'll probably take away from this, there's a fair amount of judgment involved on whether something could be eligible or may not. However, there are some key factors that we can use to push it in, both for a patent eligibility standpoint, technological advancement, and the technological advancement related to SR&ED tax credit claims. Okay, Europe had 15 examples, Canada another 14, and the US with 8. Now, when we say only 3 are eligible and 5 are ineligible, I guess, and we've talked about the US examples last year, the reality is that the ineligible examples still have what-if scenarios that they talk about here to show what's really the cutoff between an ineligible type of work and an eligible type of work. Okay. So some of the things that all of the offices agree on is that the AI must provide what they call a technical contribution. It excludes what they call abstract math or business logic, so things that just predict business functions, let's say, or marketing functions, things along that nature. There, as Ben mentioned, there can only be human inventorship, and we want to have the effects reproducible, so it can't be what we call a black box solution. We have to kind of understand what were the factors or the parameters that we put in to allow us to make this advancement, or we can reproduce the advancement via concrete performance of real-world devices or processes. Okay, and we'll talk about some examples of that. So as we said in the snapshot, some of the key things are that Europe appears to be more eligible or easier on eligibility based on the number of eligible versus ineligible examples, but really, that's a general interpretation. And the reality is that each of these jurisdictions is really just trying to illustrate the cutoff between eligible and ineligible work. So one of the first examples that we'll start with is Japan. And one of the key things that they talk about is, or their key concept is using natural laws. So really ultimately what they want to do is they want things tied to concrete solutions, real world measurable parameters. So in this case, they give an example of a project. It's called non-destructive apple sugar content prediction. And what they basically have is a drone that uses a hyperspectral camera and temperature and humidity sensors, and uses machine learning to model and predict what the bricks would be on a tree. And the reason they feel this is eligible is that it uses physical light and physical prediction using environmental correction. So this is seen as a concrete utilization of the natural laws and eligible. Whereas, we would assume that had they just claimed that the model was trained to estimate sugars and didn't have that physical correlation, it would probably be deemed to be ineligible. Okay. They also go on to, in Japan, give other examples of how machine learning is used to predict gaits of people, again, with cameras to predict certain kinds of medical ailments. And again, as long as they have the tie-in to concrete real-world performance, whether it's physical characteristics or something like that, generally they feel that's the inventive step, but that's what they call the concrete technical means that they want to see evidence in an eligible project. Okay. Now, in UK, they use something called an AeroTel test. So ultimately, what they want you to do is a 4-step process, which they've used for prior application. And in the last year or two, they've actually started to shift over to something called signposts, which is kind of a variation of the AeroTel test, but with some differences. Okay, so ultimately what they say is they want the signposts to improve the internal computer function, system performance, control external technical processes, and things like that. They give an example of a neural network that's trained on output vectors and uses a hardware scanner, okay? And it allows faster computer operation, things along that nature. So again, these are kinds of things that are similar in there. One of the main differences that we see with, sorry, if we go back one. One of the main differences that we've seen recently, and this is a subject of contention, is that using AI to predict emotional perceptions. So what user feedback or feelings might be is starting to be an area that's in the gray area. And there was a ruling where something like this actually won, but it's being highly contested. So these are areas that are unclear, even in the patent legislation. Never mind SR&ED. So all things that are potential areas of eligible claims. Okay, the European Patent Office uses something called a convict approach. Okay? So, and they provide examples here of bitrate streaming things and using physics or modes and stuff. So again, some interesting examples that we can go into. But what they do is, again, show that it's generally the eligibility is tied to things that are measurable or have some kind of measurability in the real world environment rather than just fundamental processes that are processed on the computer, predictive algorithms that way. Okay, so one of the key things, they'll give you examples of things like genetic algorithms to optimize supermarket shelf layout or something like that, which is a 100% business method. That would typically be ineligible. And under most of the rules, and there's an illustration using the convict EPO rules. Okay. One of the things that's common, and the EPO is probably the best at talking about it, is that they want disclosure. That they give examples where something might have been eligible, but there was not enough disclosure in the patent document, or let's say the SRED document, to talk about what you did. So effectively, they say you shouldn't have, the reader of the patent shouldn't have to do their own research to figure out how to make it work. All right, Canada, as we said, released about 14 different examples. And one of the key things that Canada looks at is what they call a purposive construction test. Okay, so they want you to identify essential versus non-essential elements. Again, have a real-world problem that we're trying to solve. Determine whether the use of the computer is essential to it or the software, and only claim the essential technical elements. Okay, so what they provide us with is several examples. One of the flagship examples is example 12, I'd say, of their handouts, which talks about an on-device CNN, which is a convolutional neural network. And that's kind of like a specialized network for grid-like data, things like images and videos that can create things like spatial hierarchies and is often used in computer vision type stuff. So what they want to do here is use one of these CNNs to solve a real clinical problem. Inside the body, there's ECG signals that they're measuring for your heart that are extremely noisy, and the battery life of the typical device that they have in there, they want it to be 10 years or more, and they want it to be a certain size, 5 centimeters cubed. So the invention that they cite here is a tiny custom 8-bit fixed point CNN will be put on this device. It will denoise the signal and allow it to achieve these parameters. And again, this is an example of what would be eligible type of work versus just working on a generic computer, something like this, without that tie-in to a real-world device with measurable parameters would probably be seen as ineligible. Okay, so ultimately, what they're saying, or one of the things they emphasize in the Canadian rules, is that you want to show things that are unexpected or outside the norm of standard procedures or prior art, or however you want to call that, right? So if we use the CNN for just post-processing things in a hospital or things like that, that would probably be seen as ineligible types of work. All right, so Ben already went into a fair amount of detail about the two-step process, what they call the Alice and Mayo process and examples in the United States. And ultimately, what it means in here is that almost every AI claim for step one is going to be seen to be a mathematical concept. So ultimately what we want to do is go to prong step 2A or prong 2, and does it integrate a concept into a practical application that improves technology? And that's kind of how you're going to win it on in the U.S. Patent Office. So they give a very good example, example 39, of what they call a predictive fiber cut detection in optical networks. So the problem was that in physical fiber cables, they degrade slowly, and they can have breaks that are undetectable until the light actually stops. So the invention in this case was to use an RNN, or what they call a recurrent neural network, which has loops and connections that allow the information to persist, as opposed to classic versions which have information vanishing or exploding, kind of like the DeepMind case. So what they want to do is they wanted to use the RNN to look at what they call optical time domain reflectometry, OTDR traces, and use them to control and reroute traffic. Okay, so the claimed improvement was to reduce the unplanned outages, and ultimately they say that the claim recites an improvement to the technical field of network reliability. So they were able to, maybe they didn't know exactly how the ML was working, but they were able to apply it to a situation here, a real world situation, as a technological advancement. Okay, so what are some of the areas where everyone agrees. There's what they call cross-jurisdictional alignment. So some of the key things are that they want technological effects, that they exclude abstract ideas or abstract mathematics, and ultimately they want human inventorship to be integrated. At a high level overview, so we can just pull all these concepts into one slide. I don't think there's much more to talk about this, but it just shows that ultimately we have similar concepts with different terms being used by the different jurisdictions. And as you know, when we analyze it, ultimately I think that the concepts that they're trying to predict or illustrate are largely the same. Okay. I've just given this more as a reference screen to talk about some of the examples you might want to look at on consistency. Semantic NLPs. Those are natural language processors that try to understand the meaning or the context of words within a sentence. So, you know, they would understand the difference between different synonyms within a sentence. Those are often seen, work in that area in EPO is seen as generally non-eligible. Okay. US is a little more flexible, and they like things where software security enhancements are usually patentable, whereas in other jurisdictions, similar types of work are borderline. The UK is one of the main ones, as we said, that's very interesting, in that they talk about emotional perceptions. So this is an area that's getting kind of into the social science and the ability of the machine itself to predict human behavior, human responses, which again, usually isn't quite as measurable because that's subjective. However, there's some uncertainty in whether that work could be eligible or not. Okay, and as we said, in Canada, they use what's called the essential elements test. So do we use computer hardware ideally to use the machine learning or the AI on computer hardware to determine whether the work's eligible? Okay, so some of the things that are kind of universally accepted as being eligible would be kind of robotics control, medical signal processing, things like ECGs, EEGs, some of the safety things like network intrusion detections, and other medical things like image reconstruction for MRIs or diagnostic tools such as that nature. Okay, some of the things that typically would be ineligible, things like customer churn, things that are more financial, customer churn predictions, the semantic document stuff. So as we said, things that understand the natural processing and the meanings of words, as opposed to things that create concrete improvement performance that can be measurable. Okay. So the inventive steps are pretty much the same, I would say, in all of the jurisdictions, with the slight differences that we talked about. They just use slightly different terminology. And once you're familiar with that terminology and the fundamentals within it, I think that the examples that they provide can be understood in a common framework across the different jurisdictions. So some of the key things that you want to look at, both for patent filability with AI, but also for SR&ED claims, is it in a technical field? Does it have measurable effects and features? Can we reproduce it? So is it a black box, or can we talk about the parameters that we fed in order to make it work? And that ties in again with the human inventorship side of things. Okay, so again, how does this tie to SR&ED? Well, as we mentioned before, I think the rules kind of The patent rules force the claimants to articulate certain things, such as the problem, why the existing methods were insufficient, being the claims, what novel technical approach was envisioned. All of these, I think, would be mapped directly patents, again, as a resource when doing work in the AI environment for SR&ED. Just a quick kind of reference here of some of the areas to look at, the buzzwords for 2025 on where a lot of research is going. So things like artificial networks, convolutional neural networks, recurrent neural networks, long and short-term memory sequences. All of those were referenced in the various examples that we talked about in here and that are available in the note pages to this presentation.
Thank you, David.
Okay, thanks.
You want me to do your next one, or are you going to do your...
Oh, if you could pull it up, that'd be great. I'll just walk through it.
Wrong answer, no problem.
Or do you want? Yeah. So
no, it's no problem. I've got it.
I'll just take a brief 2-minute break here.
Yes, it was a problem. Thank you.
Okay.
Yes, go ahead, David. Thanks.
Thanks. Go ahead, then, please. Next slide. Okay, so basically one of the key things that we talk about when, as an accountant, when I'm talking to an owner-manager at the end of the year, is the concept of whether to pay yourself a salary or a dividend. And this is, probably misunderstood by a lot of business owners, I find. And one of the key things that an accountant is going to walk them through is something that they call tax integration test. And what it says is there's kind of a couple different ways that you can take your money out of a company. One is by dividends. And so you leave the money in the company and pay the taxes, corporate taxes on it, and then pay yourself out as a dividend at the end of the year. The second is to take that income that would be taxed in the company, pay it to yourself as a salary or bonus, pay the personal tax on that, and because you've already made that expense to the company, there's no income, you avoid the corporate tax and you basically just pay a personal tax. And the third scenario that we're going to look at in the after-tax result is what if we pay, instead of a regular salary or bonus, what if 100% of that time of the individual is qualifying SR&ED salary to the owner? Okay? And what would be the net tax effect after tax cash in your pocket under each of those three scenarios? Thanks. So what we have here is a first situation where we have a salary of $1,000, and in scenario one, we're going to leave it in the corporation. Now, we're going to assume this is an Ontario corporation. In Ontario, corporations pay a corporate tax rate on the first half $500,000 of income of 12.2% combined federal and provincial rates. And after that, it'll go up to 25 to 26.5%. We'll assume it's 26.5% for our calculations. So there's an incentive, as we're going to illustrate, to have income over $500,000 paid out or bonused out to owner managers. And we'll talk about why that is here. So we see under the two scenarios that if the income's under $500,000 and we earn $1,000, the tax rate in Ontario at the corporation would be 12.2%. So we'd have after taxes $878. If we assume the maximum personal tax in Ontario on the dividend, if and when it's paid out. Now that tax is only payable when the dividend is paid, so it can be paid this year, it can be paid 20 years from now. So there's what we call a deferral and a time value of money assumption in this. But ultimately when that dividend is paid, assuming that the tax rates are similar than they are this year, we're going to have a maximum rate of 44% on the dividend, so we'll have a net after tax of around $492. Under scenario two, assuming we're in roughly the top marginal tax rate in Ontario of around 50%, we'll pay $1,000 salary, we'll have 50% personal tax, and we'll have a net after tax of $500. So effectively what we have is two things. We have a deferral of tax, because under scenario one, we have $878 until we decide to pay out that dividend, which may be this year, maybe 20 years from now, as we said. So we have a deferral of tax of $378. We have the $878 versus scenario two, the $500. Okay? But ultimately, at the end of the day, there's a net cost of $8. And really, that's really a difference between when the federal tax rates are set up, when the federal rules are set up, and these are federal rules, they assume that the provinces are always going to be a certain percentage. So the fact that it's not exactly zero is, and it will vary from province to province, is really a difference of the provincial rates versus what was expected when the federalization was done. But ultimately, it should amount to almost zero. So the result being that an owner-manager on income under $500,000 should be ambivalent between getting it as salary or paying it out as a dividend. As the income goes over $500,000, we walk through the same scenario, we can see that there's actually a cost to not bonusing out that income. It's roughly 8.8% in this case. Okay? So this is assuming that it's salary or dividend without any SR&ED credit, so that the $1,000 that's paid has no SR&ED involvement, and this is how it would work for most companies. Okay. Next, please. Okay, so as we mentioned there's two major effects here. What we're going to talk about is on the next slide is that there's two major effects. We can have a negative deferral of tax, and we can have a permanent tax savings. Okay, so we're going to illustrate that in the next slide. Okay, can you go back 2 slides, Earl? I think we might have skipped one. Yeah, I'm sorry. Let me just talk about this slide. Sorry, we've jumped over this. So let's go back to our previous example, and now we'll assume that the $1,000 that we spent was SR&ED wages. So we'll talk about it, but ultimately we can get up to 66% of what we paid back in an ideal scenario. What that would mean is that we have the $1,000 of SR&ED wages, we have an increase of income of $660. We're going to have to pay tax at the 12.5% or 26% on that those credits when earned, which gives us an extra $579 available for dividend. If we assume that 44% tax on that dividend, or $244. We have a net increase after-tax cash of $325 versus the scenario 1 on the previous screen. Okay. If we add that to the fact that we also have now the salary that we wouldn't have had before, even if the tax rate's 50%, we have $500 from that, meaning after tax we have $825, meaning that we have $825 versus the $492 under scenario 1 if we paid it as a dividend with no SR&ED, meaning that the ultimate savings was $333. Furthermore, because we get those credits, basically the $660 of credits even after tax, there is no deferral of tax. There's actually a prepayment of tax by not claiming the SR&ED credits in this case. Okay. So going back to highlight what the last slide said, that ultimately there's not any deferral of tax in this case. In fact, there's a prepayment of tax if we assume that an employee is 100% SR&ED, and there's a permanent tax savings of 33 to 36%, depending whether we're under the $500,000 small business limit or over. So ultimately, the question is, where's that extra money coming from in the first place? And really, what we have is what would have been $1,000 in corporate profit that would ultimately have to be paid out as a dividend, so it attract corporate tax and personal tax. We pay it as a salary. The government's giving us back up to 66% of that as an investment tax credit, and those refundable ITCs, after going through that calculation, result in the $825 ideally in your pocket versus the $492 if we just paid it as a dividend. Okay. So this is kind of a complicated schedule. It's just really meant to highlight what the rules are related to salary and wages, both for an owner-manager, what they call a specified employee. That's any employee who owns 10% or more of any class of stock of the corporation, or anyone related to them by blood marriage or adoption. So the owner's, son or daughter who maybe works there part-time, they might be caught by these rules as well. And basically what it does is it includes all your salary and wages, but it excludes any bonuses or remuneration based on profit. So one of the key things is that rather than as we said, rather than bonusing out income at the end of the year, what we know when income is, and bringing it down to $500,000, if we're doing SR&D, you want to be more proactive and salary out that income. So trying to predict what your income is going to be and set your salary high enough that we can max out the tax credits if need be. So one of the key things that applies to specified employees is that there's a limit both for a calculation of the wages itself. It's 5 times yearly maximum pensionable earnings, which is around $375,000, let's say, for 2026, and a limit for something called the salary base, which represents the overhead that you can calculate your ITCs on, of 2.5 times YMP. So these various limits are kind of the limits that we would drive to in optimizing the SR&D salary for a specified employee. Okay. So as we said, those limits would be ultimately for SR&ED labor for 2026, $373,000, and for calculating your ITCs on what they call proxy or the overhead allocation, it would be half of that, or $186,000, meaning that the total amount of qualified expenditures that a SR&ED specified employee could get for 2026 is roughly $535,000. Okay. So in addition to the tax benefits that we illustrated, one of the other things that paying the salary out, whether we're doing SR&ED or not, or one of the factors that you might want to consider is that you don't want your corporation to be deemed to be a specified investment business. And that's basically any business who earns the principal amount of its income from investments or property rather than from active business. One of the ways around that is if you have more than 5 full-time employees. But ultimately, I've seen this in cases where you have active business with too much passive investment building up year after year after year, where you get perhaps millions of dollars of income that's not arguably actively needed for the business. the government really wants you to remove that money. So these rules are put in here to encourage you to take that money out either as a dividend or to pay the personal tax on it and not leave it within the corporation unless, again, it can be tied to active business. Okay. Go ahead. So part of the negative effects of being a specified investment business is you lose your small business deduction, so you pay the top rate of tax, as you said, the 26.5%. You lose refundable SR&ED credits, so you no longer qualify for that. And you're going to have a higher combined rate as well. You're going to pay basically a temporary tax on all your investment income until it's ultimately paid out. So again, paying out salary usually helps to remove some of these passive assets from the company. Okay. Now, applying this to a medical scenario, we've talked about the issues related to medical practitioner corporations or dental or professional corporations over the past couple of years. And there was a whole series of issues that were in contention from 2016 to 2021. One of the issues that we'll talk about real quick here is, is there any funding or assistance being paid to the medical corporation, professional corporation, or dental professional corporation for the research that's being done? Are you directly entitled to exploit it? This was solved by a case in the past, case of Dr. Lamy in the Hamilton Health Sciences Center. It was a landmark case, so it solved most of these problems. And one of the key things that illustrated is, and an issue of contention now is, do we have input on protocols? And where doctors may be part of a peer-reviewed paper, but a series of doctors, maybe there's dozens or hundreds of them, the real question would be, did you really have input on the protocols? Were you involved in the design of it? Or did they maybe hire you because they want access to your client data and you were more or less just collecting data for them and someone else was interpreting what that meant? Okay, so really as long as you can show involvement on the protocols, that's one of the key things that we have still to document. Okay, so as we said, that some of the key factors that we're looking at now is improving or proving and documenting what involvement you had if you're part of a multi-person study or peer-reviewed paper, and if you can detail that within the scope of the paper itself, generally that type of work would be eligible. Okay, the other issue that's still in contention is, did the Medical Professional Corporation receive any direct funding for that work? So generally speaking, if you look at the funding, most researchers, especially in universities or research hospital situations, have a contract where they're doing both clinical work and research work. And generally, most of the funding that they get is for the clinical work. So often there's no funding for the research work, or they're just expected to do it as part of their involvement with that research organization. In some other cases, it may be arguable that they were paid for the research. And the way the CRA looks at it is they'll look at something called the APP or AFP, what they mean, alternate funding. And the issue with alternate funding is that often it's supposed to pay for a whole series of things, such as being a specialist, working in remote areas, working overtime, working off hours, and research and development. So it's hard to argue that all of the AFP were related to it. But currently now, one of the main issues is, should any amount or some reasonable amount of AFP be related as a payment or a contract payment or reduction of the ultimate expenses that we claim. Some of the other things that we'll talk about is that the assumptions that we used here assume that you're in the top marginal tax bracket. So if you're in a lower bracket, that ultimately you could adjust those numbers to reflect your real situation. Okay, and I've just provided the rates that we've used for the corporate taxes as well. Okay, so again, those. What we've done is also provided in the downloads a series of workbook tables, so you can adjust the percentage of time, marginal rates, and discount value of money to determine the net tax effects. Thank you.
Thank you, David.
Thanks.
Okay, it doesn't want to let me stop sharing, but here we go. I'm pleased to announce that Elizabeth is going to take over now and talk about some federal SR&ED updates. She's been involved in the SR&ED program since 2007. Her firm, the Ingenuity Group, manages SR&ED education and resources, a website offering extensive content on SR&ED tax credit program. The site includes detailed analysis of every federal budget affecting SR&ED since 1995, summaries of over 250 legal rulings, and hundreds of academic publications related to SR&ED. It also features analysis of CRA annual reports to Parliament, dozens of other government reports, and summaries of over 100 news articles spanning from the 1980s to the present. So without further ado, I will let Elizabeth take over. Thank you.
Hello again. So it's great to be back. And yes, I love talking about the SRED program, and it's been a particularly exciting year for anyone who's been following along, either with a frontline seat or to the side. So last year when I came and spoke with you, I talked about the consultations that happened late in the year. So a lot has happened since then. Today what I'm going to be talking to you about is the big program updates, as well as some interesting access to information requests that we've had. So the fall economic statement, the federal budget, the launch of the new review guide, and a little bit about tax earned by audit and gross negligence penalties. So last time we spoke, I talked about the consultation and some of the positions that were put forward by a number of the larger groups and associations, and that culminated in the fall economic statement, which came out December 16th and proposed significant and exciting changes for the SRED program. But the initial optimism surrounding that announcement was really short-lived, since the Minister of Finance resigned and an election was called. And at that time, it was unclear whether or not we would see this come to fruition. So we went through the election, and here we are almost a year later, and we now have the announcements that were made in the federal budget, which was passed just recently, but we're still waiting for the exact details. But the high levels were in the budget document. So the big ones that people were lobbying for and were pleasantly surprised by was the enhanced expenditure limit, raised to $6 million. I'll talk a little bit more about that. The expanded phase-out range being increased when you have taxable capital. We now have eligibility for certain public corporations, capital expenditures being reinstated, and then there are proposed administrative modernizations that they're working on as well, because this is one of the largest programs in all of Canada, and there's always room for improvement. So the most significant one that will impact likely most of the individuals in this room in some capacity, either as advisors, consultants, accountants, is the enhanced expenditure limit, which has been raised to $6 million. Originally, it was announced that it was going to be 4.5, and they decided to make it even bigger, so they've doubled it. What this means is CCPC spending $6 million on R&D can now receive up to $2.1 million in refundable credits versus the 1.05 mentioned previously. Now, one thing to keep in mind with regards to this announcement, because I know I was quite excited and I sat down and I modeled it in a spreadsheet, but these are just the federal values that have been impacted. The provinces haven't really indicated whether or not they'll follow suit. So, for example, the limit on the eligible expenditures at the Ontario level remain the same for the refundable tax credits. So you won't see the entirety of the refund doubling, just the federal portion if you are in this range. The next big one is the change to the phase-out range. So if you had clients that had significant taxable capital, it began to grind the tax credit and it would decrease the refundable rate. That's been bumped up 15 to 75 million. So that is a change from the 10 to 50 million, which is quite nice. So again, if you have larger groups that were applying for the SRED program, they now have a little bit more incentive, because historically it was more the smaller firms that tended to get more of a benefit. And at least I noticed in my practice is that the larger firms tended to lose a little bit of interest because it wasn't the same sort of return that they were seeing. It tended to stagnate even if their R&D expenditures went up. The really exciting news was the eligibility being extended to some public corporations. So certain Canadian public corporations can now access that 35% refundable tax credit rate, which was previously reserved for Canadian-controlled private corporations. They were very vague about it in the budget, but in the fall economic statement, they gave more details in terms of what that would mean. So in terms of it, it is the requirements. They call it a eligible corporation. So an eligible Canadian public corporation would be a corporation that throughout the tax year is resident in Canada, has its class of shares listed on a designated stock exchange, and apparently this will be on the Department of Finance website, and is not controlled directly or indirectly in any manner whatsoever by one or more non-resident persons. So there are going to be some restrictions on it. I know it was the Toronto Stock Exchange that was really hoping to see this happen, because you'd have companies that on paper were very, very similar in terms of their R&D expenditures, except one was public and one was private, and the private company got to benefit from the refundable federal tax credits, whereas the public company didn't. So that's quite exciting. And also capital expenditures. Yeah, I really wanted to be excited about capital expenditures being reinstated because they disappeared back in 2014. But again, it's on the federal amount. Don't know what will happen on the provincial levels yet. I know a number, it tends to follow what the federal group does, then we see the provinces mirror it, but many provinces had phased this out as well. We think in our office that it will follow the prior capital expenditures policy in terms of the restrictions, and for those who had put in claims under this previously, one of the challenges was that it had to really strictly be used for R&D, and sometimes it's just not worth the hassle of putting it onto your SRED claim and then seeing if it ends up moving into production at a later date, then clawing back some of the costs. So this has mixed feelings for me. I think it'll be helpful for some groups. I know that they're looking more at their capital expenditures, but what wasn't explicit is lease expenditures, which is also a significant expense. And for the topic of the day, which is AI and machine learning, a lot of the costs that we're seeing are around, cloud compute and provisioning of data in the cloud, and that means that those expenses won't be covered under this. I don't know if that will change, but I know a number of groups would be very happy if they could get some of those costs recovered. The other big one that they announced, and we'll see how it progresses, is the administrative modernization. So we've seen a few variations of things over the years. We had the pre-claim consultation, which would tell you if there was scientific research and experimental development work. They also had the SALT tool that's still in existence. But as some people unfortunately found out, a pre-claim consultation was not a pre-claim approval. So they would go through this process and then they'd still get audited. They are now introducing a pre-claim approval. But the caveat on the language they put out was before businesses undertake any work or incur costs. So you'd actually have to be quite organized to go and take advantage of a pre-claim approval in this context, if we're reading it exactly as written. The other one was AI-assisted triage to fast-track low-risk claims. This was hinted at last year in the interview with CPA Canada, but one thing to note is that there's not saying low-value claims, because sometimes the impression is if I'm putting in a smaller claim, then it's less likely they're going to be reviewed. But they stated low-risk claims, and then there are no details as to what they consider low risk in this setting. I think it has potential to be really good, but we'll have to see how it's ultimately rolled out. And then a 90-day processing target for those pre-approved claims. So in theory, it will go through more quickly. So this is the exact text from the budget. It'll be in the download available after this meeting, but this is what it looked like in the budget itself. So they outlined the current process and then the optimized process. And for those of us, again, who've been doing it for a number of years, it can actually be quite quick from day zero to when you get your refund. The 60 days, if you're going to be approved and it's a refundable claim, it tends to go quite quickly. But they're adding in this additional pre-claim approval step, and in theory, it means that you'll be processed more quickly. Again, the caveat in here is the CRA stops the clock when they're asking you for information. Sorry, they start the clock when they ask you for information, but they tend to stop it once they're working on it. So the numbers can be adjusted, if you will. And if you have a non-refundable claim, you tend to get put at the bottom of the pile anyhow. So I don't know if this will actually make much, if any, difference, aside from the pre-claim approval being really helpful for any companies that choose to factor their tax credits and get an advance on what they have spent with a financing company. Really, again, everyone's excited about AI. I am as well. But there are risks that come with AI processing the SRED claims as well, because people will start writing it for AI to read. And I've had some groups come to me with their pre-written SRED technical narratives, and it's very clear that it's written with AI. And AI is a tool. You still need a human in the loop. So that's the big update on the budget. I'll pause at the end for any questions, but I really want to talk about the SRED review guide as well, because this was a big update and I think a much needed update to the actual administration of the program. For those who aren't aware, there's a whole guide that explains what the reviewer is supposed to be doing when they come out and speak with you. I'm not entirely sure how many of the reviewers actually know about the guide or that it's been updated. I would like to think that it's been clearly communicated internally, but my experiences recently is that there's still some people following kind of the older approach, and they have definitely changed some things in this review guide. So the review guide consolidates. There was the technical review, and then there was also a separate document that talked more about the finances, and this is now a more integrated version. What is really important to note is the messaging that's coming from the CRA right now. They want more supporting documentation. We talked about that earlier in the call when it was discussed in the Tax Court of Canada rulings. The ones that were more likely to succeed had better documentation. They really do want you to have good supporting documentation that is dated and specific to the work performed. Again, so many people are relying on AI to write things right now, including their SR&ED documentation. And the CRA can see that as well as anyone else. When you've seen a lot of AI written text, it's an issue. So be aware that that fifth criteria, the documentation was generated as a result of the work performed, is being reinforced in the SRED review guide, both for the SRED work and the SRED expenditures. The salary and wages policy has not changed, but I've seen significant pushback against any allocation methods. So keep that in mind. But one of the key clarifications as well, historically, they'd ranked the types of evidence that was being provided, and they really drive home now that oral statements are not a substitute for keeping adequate documentation or other evidence. So for that one client that likes to say, it's fine if they come out, I'll just explain it to them, that is not the ideal approach, and it's a very high-risk approach with some of the reviewers right now. Other things is the wording and the organization of the review guide. So the original review steps, when we were talking only about technical reviews, it was more geared towards the RCA. This one is more even more geared towards the taxpayer. So the new review steps include the start of the review meeting and requests for additional information, and the end of the review. I really like that there's a repeated emphasis on clarity and transparency in these documents. The actual implementation, I think, has room for improvement, but ideally the reviewer is now explaining to you why the information is needed. Not just, I need this, but why it's needed. So in theory, at the start of the review, you'll be contacted by phone, and the issues identified in your claims should be discussed. So they're supposed to be as specific as possible when identifying the issues. The get out of jail clause that they have in here is, however, the ability to do so can depend on the content of the information submitted in the claim. But really, it's there. Asking for them to be as specific as possible aligns with this guide. They are supposed to send you an initial letter in advance that will outline what was discussed in the call, as well as a list of any information being requested to address the issue. So we've all seen the shopping list letters from the CRA. In theory, they're supposed to be more targeted at this time. Again, a meeting agenda identifying the issues and related projects as well. So the word issue, you can see it's starting to come out more in this document, that they're looking to have this area communicate with you more effectively. You may need to remind the CRA of this and ask for more details. We've seen cases where the CRA has a last-minute cancellation. They try and put someone into that slot and kind of skip over some of these steps. So just be aware of pausing and asking for this information, because it is aligned with the review guide as it's now written. I thought this was really interesting as well in terms of the review meeting itself. They talked more about what to expect in it, the usual things of you should come prepared, how the documentation, and so on. However, they now outline what you should expect at the end of the meeting. So we usually get the agenda, it'll talk about the beginning part and do the training, and then go through the various issues on the technical and financial side. But here is your checklist for the end of the meeting, as it should be in an ideal situation. So the reviewers should be verbally providing you a summary of their understanding of the work so that you can correct any misunderstandings, any clarification they obtained regarding the issues. They should be explicit about the areas where they still have concerns and require further clarification, if applicable. The information that is still missing and needs to be obtained, again, if applicable, along with the deadline. The preliminary review findings, of course, there's an asterisk in case they don't have them yet, recommendations for future claims, and the next steps. So I know, at least in my experience, sitting down with the CRA, we got to the end of one meeting and they tried to cut the meeting short because we had started late due to technical issues. And it was a case of pausing and being like, no, let's take this next few moments to go through this list and make sure that we've addressed everything that's on it. And as part of that, when they talked about, well, I have a concern with X, they were able to correct it in that misunderstanding in real time. So really handy list to have on hand when you're going through the review. So it's a great update here. And then the last step covers the usual things of what happens after a review meeting, and consolidates what you should be doing. So that's the other big update, is the SRED review guide. So we have an increase in what you can expect in terms of refunds. If you have larger claims, I would expect that there will likely be more claims. You have clarification about the reviews and some of the documentation expectations. But here's where it gets a little bit colorful, is someone reached out to me and they said, I had an unfortunate experience and I filed a number of ATIPs to confirm something, and they forwarded the ATIPs to me and we analyzed them in-house as well. And the rumors that we've been hearing for years about tax earned by audit, there is some validity to it. So in one of the ATIPs, what we saw is that it is being counted in tax earned by audit calculations, and it's increased over the years. So from 155 million up to 241 million in terms of how they calculate the tax earned by audit. So that's anything that is denied effectively. And the other big thing that's happening is gross negligence penalties are starting to be applied. And you may have heard of it in a few different places, but this is confirmation that it's occurring significantly more than it did before. And that it's being applied within more SRED audits. So under subsection 163, the CRA can apply a gross negligence penalty when, in their view, the taxpayer knowingly or under circumstances amounting to gross negligence makes a false statement or omission. It's a huge financial penalty. It's huge, typically 50% of the understated tax. And it's gone up dramatically in the SRED program. So if we look all the way back to 2018, there were only 3 cases of it being applied in SRED. It dropped. I mean, we can assume some of that is due to the pandemic, but coming out of that, we've seen it dramatically increasing for the last few years. And the total value that's come out of it is significant as well. So $2 million to $4 million to over $5 million. The number of fully denied claims from the SRED program, I mean, it's varied, and the amounts have unfortunately gone up. So 2020, when it seemed like everything was being approved, effectively it was. 2021, 22, there was more scrutiny. But if you're feeling that there is more pressure in 2023 and 2024, it's correct, that impression. It's definitely increasing over the last few years. So that's something to be very cognizant of. Again, if you have a client who maybe has skated a little close to the edge, it's time to firm up those practices, because this can directly impact them in a way that can be devastating for their business. And it's very difficult to fight these. So it's an unfortunate situation because the SRED program is ideally intended to encourage businesses to apply. But if auditors or directors are being assessed based on TIBA, which is the rumor, and it's being counted, that contradicts an incentive program. And applying gross negligence penalties more aggressively also acts as a deterrent. I know that some of the loveliest groups that I work with who are 100% on board, even they're concerned. They're like, well, what if they misinterpret what I said? So it's had a chilling effect. But it has its place, because there are some questionable claims that are being submitted to the CRA. But this is quite substantial. They didn't formally link TIBA to compensation or performance pay in the ATIPs, but the Ontario Auditor General did identify it as one of the main internal performance indicators. It might not apply to SRED. It wasn't clear in the ATIPs we saw and we reviewed. But without greater clarification, especially in relation to this program, it's likely going to cause some challenges, because I don't see these numbers going down in 2025. I would expect that in 2025, these numbers will continue to increase. So for further reading, there are a number of articles that we've written on the topic, and we'll be writing more about it, about the budget, about the changes to the review manual, about TIBA and gross negligence penalties. But I'm going to pause here to see if there are any questions about the program changes and give everyone the opportunity to ask questions.
I think one of the things that to mention is Manitoba never phased out capital, so they're fully in line with capital, just for the
That's great. Yeah,
viewing pleasures. The other thing that would be interesting, and I assume, but you know what happens when someone assumes something, what that stands for. If CRA is using AI, I assume they have their own internal database, like some big corporations do, such that it does not become public knowledge. And I don't know if there's anything specifically on that topic. I mean, it should be because that, but I don't know if you've seen anything specifically related to that.
They alluded to that in, there was a director who did an interview with CPA Canada last year, and she alluded to using AI to process claims, and the budget does seem to suggest they're going to start using AI to process claims more quickly. It would be an in-house tool, but there's very little that's publicly available beyond that.
And I think your point about the whole gross negligence penalties, what I found interesting was there was only 3 applied in 18. It's almost the same amount as was applied for 80, 68 million versus 76 million of denied expenditures. So I guess there's a lot more people doing smaller gross negligence. But yes, I think it can be a deterrent, but my humble opinion is it's good for our industry to get some of the less scrupulous people out in the companies. I mean, I think everybody's heard about the one many years ago where they did a city block and every single person, including this corner store, was put in for a claim, and if CRA came to audit them, they withdraw them. And of course, you can't do that anymore because CRA will not allow you to withdraw them. That's how they stopped that. But so it's not entirely bad in my humble opinion.
I would agree with you. I think there's a place for it because there's no barrier, as most people on the call will know, but for those who don't, there's no barrier to entry to becoming an SR&ED consultant. There's no degree in SRED consulting. There is no professional exams. So someone who's left their job or been terminated from their job can wake up the next day and claim to be a SRED consultant because they may have written one back in 2015. So there are some questionable characters. There are some individuals who don't have as much experience. The challenge is that, and this is a rumor that has not been confirmed, but that the gross negligence penalties are not just being applied in obvious cases, but also borderline cases. And that can be a little bit challenging from what I've heard. Now, I see Justin has his hand up.
Just before we get to that, there's a couple of questions. There's one in particular that relates to this discussion we're on, and it's, are there any examples of what negligence actually means? Is it about making false claims or exaggerated claims?
Yeah, so that's effectively what it means, is by deliberately misstating or omission. I didn't prepare the claim, but I have seen one where they copied and pasted the exact same technical narrative over multiple years. And they had no supporting documentation for what they were doing, and they wrote all of their supporting documentations the day it was requested using AI. And that, I mean, anything that you would consider, I think, borderline fraud and knowingly misrepresenting your work is that would be for me the boundaries of it. But if it's a routine disagreement between what is and isn't eligible, I mean, we have these disagreements all the time with the CRA, right? We're always saying, well, you know what, we put it in because we sincerely believe this to fall within the boundaries of the program, which is different from, you know, I claimed my dog on the tax schedule as a specified employee and paid him $100,000. Like, fraud is really the boundary here.
Absolutely.
Well, I've actually, I inherited a client from another preparer who they had been claiming successfully for about 6 or 7 years. Mind you, I don't believe they had been previously reviewed. And when they went to review, they were found to be substanceless, and the prior preparer did not attend the meeting. And that was enough for them to apply a $75,000 gross negligence penalty.
Interesting.
Yeah.
Before we get, there's one other question, but people can feel free to submit questions before or after. One of the things that we wanted to talk about and hoping to get some feedback before I get to the last question, but again, there's time for more questions. We're looking at potential topics for future events. One of the things that has been brought up and I think might interest a lot of people is you may be aware that Quebec has significantly revamped their system, and therefore it may be interesting for a session to be done on what the new system is like and highlighting the differences between federal and Quebec, because they are fairly significant now. Another item that people have mentioned that might be of interest is detailed artificial intelligence patent examples. Then another third one is SR&ED tax planning issues similar to wages. So that's another one. If people have any other ideas, we would love you to submit them to us. So you can either send them to myself, earl@vinerrnd.com, or to david@dsabina@muke.net. And then now I will get back to the other questions. So a good question is, are there any signs of more on-site CRA SR&ED audits instead of virtual audits? So I'll open this up to any of the panelists.
Not here. They're
Not
still
here.
all teams.
Yeah, they love these virtuals is what I've seen. You really got to drag them out if you want to try and get them there from what I see.
I've actually tried to bring them out, and they went to their manager and hid behind their manager saying, no, we don't have the budget for that. Despite the fact that on a national labor allocation, the auditor was within a 30-minute drive of the taxpayer.
Yeah, I mean, now in theory, they are allocating the claims out to different offices where whoever's got availability as opposed to one that's close by or might actually understand what you're doing. David, do you have anything to add to that?
No, I'm in agreement with what you guys said.
Next question. Has anyone observed any trends in terms of quantity or intensity of reviews? Can you describe where you think the review experience is currently and where you'd like to see it?
I currently have 12 files in CRA, and all of them have Integris case numbers. I've never seen anything quite like it.
Yeah.
Sorry, what? Have which?
Integris, their internal, like their case number. Like once it gets an Integris number, you know you're into, at a minimum, a desk review, but more than likely a coordinated review.
I've seen them go up, and we've just been really fortunate, and we've had very few over the years, touch wood. But the ones that I'm seeing I feel like they're less organized. We've had reviewers show up having not read the materials that they insisted they needed at least 30 days in advance. We've had reviewers saying that you can't run tests outside because you can't control the weather. We've had other statements that, don't really align with, I think, best practices. So, I don't think that the quantity is higher and the quality, I don't know if the quality is where it needs to be. I've had some of the really old school reviewers as well. I had one who I think has been at the CRA for 30 years, and he decided he just did it the way he wanted to do it. And he was hands down the best reviewer we had. He was very difficult, but you knew exactly where you stood with him. And I miss those types of audits.
What's interesting is looking at some of the audits that I've seen where I've been brought in to assist on accounting firm issues as opposed to R&D issues. The auditors there, at least the experiences, they're much worse and less experienced and not as focused. They really don't know what they're asking for. So it's very interesting. So I think from a certain degree, we're fortunate in the R&D area, and maybe I'm even more fortunate that I haven't had too many R&D audits. And it's a nature of my clientele or the claims, I'm not sure, but I can't comment on whether they're more harsh or less harsh because so far no news is good news. Next question. Will CRA continue with their focus on a national approach to CRA audits, meaning the RTA and financial reviewer could be from different regions across Canada from each other and or taxpayer claimant? I think from my experience and my understanding is they're doing this purposely to be more efficient and therefore get your claims faster. and do it better. I'm hoping they're also using it as an excuse to make sure they got better people for the claims, so they're more relevant. I don't know if
Don't
anyone's
worry, they're not.
Anyone have any experience or comments with respect to that?
National Workload Administration is the bane of my existence because very often I find that I'm 2 and 3 time zones different from the reviewer.
That's
I don't know
because
if
you're
you've also...
working in a very remote area.
Well, that might be the case too.
Maybe nobody wants to go up to you.
Oh, I know they don't.
Especially in the winter.
No.
Personally, I found that when they do the reviews, it's pretty comprehensive. They usually do the technical and the financial together. However, I found it's been pretty efficient using the My Account. So if you have the client has My Account services for the CRA website, you can usually upload all the information, the request for information, and supporting documents back and forth fairly efficiently. And I don't know, I found that when the review's done, the CRA reviewers have been pretty reasonable in most cases. So no complaints on that end. So again, I find the service is actually getting more efficient, I think, than it was 5 years ago.
So the question that I had following your presentation, Elizabeth, was entirely a mechanical one. When there are changes made that are substantive enough to warrant a new edition of the T661 form, like recalculation of expenditure limits retroactive to December 2024, well, I guess two-parter. One, do we know when the next version of the T661 is going to be released? And two, I actually have a publicly traded company with a March 31, 2025 year end that has filed that they will be candidates for refundability. Will CRA revisit those internally and then issue a refund? Or do we have to do differential calculations of the expenditure limit or the conditions across that time? Or do we have any of the answers to any of these questions
We don't have any of those answers right now. It is, from what I can tell, we are just building the airplane as we're flying it, be it the tax software, be it the forms at the CRA, because one didn't even know if that budget was going to pass. And then there are still a number of steps that need to happen before, they figure out those details. But one thing I'm fairly confident will not change is the 18-month filing deadline. So whatever the CRA decides, if you only have 2 days to sort it out, you only will have 2 days to sort it out because I can't see them extending that. But Earl and David have been around for a while in this space and survived a few of these changes. Maybe you have some additional insight here.
CRA is not going to be proactive. You have to protect your client, and with the deadline in mind, I would file revised forms based on the new rules.
Yeah, I'd manually calculate it if I had to.
And yeah, if forms don't work, then just force them. Basically is what I would recommend.
That's a very good point.
I would also watch for Department of Finance when they pass the draft legislation into law, and then we know it's in or out. Ultimately, I think the only real issue would be with respect to doing amendments if we're beyond the 18-month filing deadline that we alluded to, and so we have periods that apply to, but it's not really an issue right now for periods that this would apply to, the new credits, that is.
Yeah, it'll start to become an issue come June of 2026. I agree.
Okay, one other question is, how can a claim be pre-approved without any systematic investigation actually done, documentation done, or technological advancements gained? Hasn't that been the basis of the entire review process for decades and not just the technological uncertainty which would be known up front?
I mean, ask the National Research Council that. They grant money based on plans all the time. I think there's lots of evaluative mechanisms, but of course the caveat is that the approval comes with an understanding that the subsequent work has to be reflective of that which was covered in the PCC or the PCR, I guess.
PCA, I think will be the new abbreviation. But I mean, that brings up a really good point because with the pre-claim consultations, the costs were starting to be incurred. You had more supporting evidence and so on. But with the pre-claim approval, you're right. If it differs substantially, is it still an approval?
I suspect there's not a chance. It's still an approval. But, I mean, again, I guess the mechanisms for something like IRAP under the National Research Council, they have interim reports over the course of the year, right? So they have check-ins to find out if the guardrails associated with the approval are still in place. But it sounds to me, I love that, flying the airplane and building it at the same time. That seems to be what's happening here too.
My experience with the pre-claim approval process has been mostly positive. I've only done it in a couple of seen it in a couple of cases where clients kind of had financing or were really leery about financing a project unless they had a reasonable assertion they were going to get the credit. So they did the pre-approval. And what ultimately I think you need to do is ensure that what the ultimate research was consistent with what you submitted. And most of the problems that I've heard of people not, the CRA not adhering to the pre-approval is usually because what you said you were planning to do doesn't necessarily match up with what actually happened. And I think if you understand that fundamental, then everything kind of falls into place.
Next question. Don't you have the recent impression that CRA sometimes refuses a claim for budgetary reasons independently of the claim's quality? When it happens, they don't even listen to explanations. That's interesting.
I wouldn't suggest that, at least amongst my clients, nobody has a materiality of claim that would move the budgetary needle in any way. I don't think that's the issue. Although I will say that I think the greatest failings I've had in reviews have been essentially a differential or a schism between what I'm communicating and what the auditor is understanding. Now, I've actually had a pretty good run in the appeals process, independent of the actual audit process, and maybe take a look at something differently when you filed it 3 years ago. But that tends to be, I wouldn't suggest that there's any sort of SRED budget, or, I mean, who knows, based on the tax earned by audit, maybe there is something in that respect, but likely not largely in the case. Richard Wong's question, do
yes,
budget rules apply? Yeah, only to fiscal years end or start after December 13th. Yeah, but my suspicion is that there's going to be some sort of breakover rule. There usually is, that you have so many days within the period. So like your $3 million expenditure limit, if you've got 30 days into the breakover period, I mean, maybe we don't know.
It's December 16th, not the 13th. Too.
Yeah, that's right. My son's birthday. That's how I should remember that.
So the exact wording is effective for taxation years that begin on or after December 16th, 2024.
So it will not impact that. Next question. Are particular industries that have been fined for gross negligence or involved in tax schemes that have been targeted by the CRA? So they're specific.
That wasn't in the breakdown of what was sent in the ATIPs, so it just gave the aggregate. It might be an interesting follow-up to see if maybe it's the food industry, because I know someone reached out to us about they'd been targeted with the GNP and they were in the food industry, but I haven't seen anything.
Unrelated to R&D per se, but you can see they plowed a whole bunch of money into truckers, so they don't trust them for whatever reason. So I don't know that there's any serious claims in the trucking transportation business per se, but certainly CRA has seen that as an area for underreporting of income. We still have some time if there's any more questions. And again, you can submit ideas of what you'd like to see or hear in the questions, because that only comes to us. And we don't need to read those, but we'll then know. Okay, another question's popped up. What's the best way to handle those miscommunications during a review where the RTA is clearly not hearing or understanding what the claimant's describing? Does it have to go to appeals? And if so, any tips on how to succeed at that stage? No, it's very simple. If your reviewer is not doing that, you just got to go to the manager.
Yeah.
A lot of times you got to bring the manager in because, quite frankly, the RTA or the FR just does not understand some things that just haven't been around long enough. And they're not familiar with it. So it's reasonably often, but clearly no. Appeals is much later in the process. Anyone else want to make comments related to that?
Well, I just refer back to what I said about using the My Account. And if you can have all the documents uploaded under, they usually give you a case reference file, then it's easy to bring the manager in because they're going to have access to all that information in an organized manner. And the more documentation you can provide up front, the easier that's going to make the process. The less assumptions they have to make and the more definitive you can make it, I find the smoother that goes.
Related to this, I find that the manager doesn't always support the reviewer, especially if they're really wrong. And a lot of times they will pull them aside to discuss it, if not actually there later on. So you will see the manager does have a positive impact. They're not there. It's not like the police shows where you say if you're in blue or whatever, you got to protect the other people in blue, the blue wall. It's not like that. What I've found is that the managers, especially since, I mean, at least from my experience, most of the managers we know, so they know we're not just blowing smoke up, that there is an issue with a reviewer for bringing it to the manager. The next question. Oh, did you want to make a comment?
Yeah, I just wanted to add that one strategy that I think not enough people are using is that you can submit a one-page summary to an auditor when they show up, and they will look at it and they will take it into account. And sometimes that's much more efficient than just passively answering the questions, right? Especially if you show up to defend a claim written by another consultant or by a non-consultant. Those are the worst. If you can summarize the essence of the claim in half a page and show that to the auditor as soon as they show up, that can save a lot of effort and a lot of misunderstanding. And I haven't seen that used a lot.
I actually, I go the opposite route. I actually use the long form. I drag out my old 2003 version project description framework, and I explain in more detail sort of working on okay, you've got 1,500 words of it. What if you have 2,500 words of it, where I can get into some of the more detailed iterations? I've also found that to be successful too.
Yeah, but usually when the audit starts, they're not really in the mood to read a long document. They're eager to get...
Oh, no, that goes 30 days before. I get that to the auditor well in advance.
Oh, okay.
I've even had one who rescoped the audit after receiving long form. There were 4 projects that were under scope, and he decided that after reading the long form of all of the projects that he was only going to look at one of them, and that he accepted the others as filed. So it happens. It just, in that case, I knew the auditor well enough to understand his approach to the projects, and yeah, that kind of comes with some experience too.
Sure, makes sense.
Next question. We have an appeal that has been outstanding for more than 2 years. It still hasn't been assigned to an auditor. Is this normal? Unfortunately, It's very normal, and I think it's only going to get worse, quite frankly, as more claims go in. I mean, you've seen some of the cases here. We're talking about 10, 15 years before they get to the courts, and then they get appealed even after that. So, and yes, I know you're just talking about appeals, not truly the courts per se, but even within CRA, it's a very long process. So is it normal? Yes. Are they trying to address it? In theory, yes. Will they? I don't know. Anyone else? Comments? Okay then.
Twiddling my thumbs on a couple, for sure.
Do you think that the success rate in objection is so low with a CRA acting simultaneously as both judge and party that any dispute should be escalated to the Tax Court of Canada after 3 months. I'm not sure it's fair to say that notice of objections are not successful if they're done well. I don't know. I mean, ideally, the best thing is to obviously get things resolved before you get to that stage. But I don't know if anyone wants to comment as to whether they're finding the success rate with the notice of objection is very low and therefore should go to Tax Court of Canada right away or not after 3 months.
I mean, maybe after 3 months, I might get a lawyer, go and talk to justice and say, can we settle this so that it doesn't go to court? I've done that too, and that's been successful.
It might also depend on the amount. If you're talking informal appeal amounts, under 25,000 credits, those tend to go a lot faster than a formal appeal. So
They're
all
bumping
factors you
up,
might
they're
want to
bumping
consider.
up the informal now. Threshold is going up to 50K.
Certainly a small claims court, I don't know, but informal procedure, but maybe they're probably going lockstep, so it wouldn't surprise me. Well, let me take the opportunity to thank all presenters, Sean, Ben, Justin, Elizabeth, Ohad, and David, and also thank Elizabeth and David for significant work in making sure this happens every year. I'd like to thank all the people that are here, and 90% of you were very useful and involvement. But again, I'd like to see, we had one idea of something we could present on in the future, but haven't heard any feedback on some of the things I mentioned as to whether people would like to see some of those things. So hopefully my email or David's will be overwhelmed with suggestions of things that they want to see, because certainly people haven't dumped them into the questions and answers. On that note, David, do you want to say anything in closing?
No, thank you, Earl. That was great. And again, we'll hopefully keep this going at least once a year. And I think the feedback and response has been great so far. Thanks again.
Yes, please feel free to send any feedback. Be happy to see it. And we ended 9 minutes early.
Excellent. Hope everyone has a great weekend.
Thank you very much.
Take care.